Guys, an update of the Ripple and SEC lawsuit update. Okay, it was released last night. So this comes from James K. Filing on Twitter. Okay, Ripple defendants file letter notice of supplemental authority in further support of the fair notice defense. It's the decision of Judge Michael Wiles in the Voyager bankruptcy case. Well, Wiles rejected the SEC's obligations and approved the bankruptcy plan. Okay, let me just hop on over to Dropbox. Okay, here we go. Okay, these are the Ripple lawyers I'm talking about now. Okay, Kellogg, Hansen, Todd Weigel, and Frederick P. LLC of Washington DC. These are the lawyers. Okay, here we go. Honorable Annalisa Torres, United States District Court, Southern District of New York. Dear Judge Torres, Defendants Ripple Labs Incorporated, Ripple, Bradley Garlinghouse. I can't get used to that name, Bradley. I always call him Brad, but Bradley? That's okay, that's his name. Bradley Garlinghouse and Christian A. Larson respectively submit this notice of supplemental authority relevant to their opposition to the SEC's motion of summary judgment. Okay, here we go. On March 11th, 2023, Judge Michael Wiles of the U.S. Bankruptcy Court for the Southern District of New York, it's the same district as Judge Torres in the Ripple case of New York, issued a ruling in Voyager Digital Holdings Incorporated. Okay, attached here too as Exhibit A, this ruling provides further support for the defendants' fair notice defense. Okay, Voyager concerned the bankruptcy of Voyager Digital, a digital asset brokerage company. Under the proposed bankruptcy plan, Voyager would sell its assets, including a digital asset called VGX, to the exchange Binance US. The SEC objected to the plan, arguing that VGX had aspects of a security without specifying what those aspects were. Okay, this is the SEC all over again. It further objected to Binance US. This is the SEC objecting. Binance US was an unregistered securities exchange without specifying why the SEC staff thought so. Okay. Judge Wiles rejected the SEC's objections and approved the bankruptcy plan. His basis for rejecting those objections endorsed many of the arguments defendants have raised here. First, Judge Wiles rebuked the SEC's attorney for the vagueness of their objections, noting that SEC had not offered any guidance at all as to just what it was that the debtors allegedly supposed to prove. Okay, in order to show that VGX was not a security, I reject the contention that the court and the debtors somehow were supposed to figure out for themselves just what aspects of a VGX token might be considered to be aspects of a security. Okay, he also emphasised the limited guidance that SEC has provided generally to market participants. Second, just as defendants have highlighted in connection with the fair notice defence, Judge Wiles found that cryptocurrency market participants operate in a regulatory environment that at best can be described as highly uncertain, in which regulators themselves cannot seem to agree as to whether cryptocurrencies are commodities that may be subject to regulation by the CFTC, which I think they should have the power taken away from the SEC. Regulation by the CFTC, or whether they are securities that are subject to the securities laws, or neither, or even on what criteria should be applied in making the decision, an uncertainty that has persisted despite the fact that cryptocurrency exchanges have been around for many number of years, which of course have been cryptocurrency exchanges has been around many years. Copies of the March 11th opinion and relevant hearing transcripts in Voyager, along with a copy of Judge Wiles' order denying the government's motion for a stay of the March 11th decision pending appeal. I don't think they're going to appeal it. SEC, don't want to have a chance. Are attached as exhibits A to C. For the court's convenience, we thank the court for its consideration on this matter. Respectfully submitted, Michael K. Kellogg, Hansen, Todd Weigel, and Frederick P. LLC of Washington. Clearly Gottlieb, Steam and Hamilton LLP of Washington, D.C. and DB Wheels and Pimpleton LLP, 3rd Avenue, New York, and Paul Wise, Rifkines, Watson and Garrison LLP, Avenue of the Americas, New York. Counsel for the defendant, this Chris L. Larson. Counsel for defendant, Ripple Labs. Jesus, how many? They got 1, 2, 3 different law firms supporting Chris Larson and Brad Garlinghouse. So there you have it. So in other words, Ripple last night sent all the paperwork, all the documents concerning Judge Wiles of the same district of New York on the Voyager case to Judge Torres last night, because the judge ruled in Voyager and Binance's favour for the plaintiff, okay, and that's going to help Ripple in their defence, fighting for fair notice and oh right, it's okay. So it's okay. I was just reading something here. Yeah, that's going to help Ripple fight fair notice on their defence, and we'll have to wait and see, because hopefully the Judge Torres, she'll read this later today. Well, her secretary will, and she'll pass on all the information. She'll read it, take a few days to read it probably, and hopefully Judge Torres will rule by the end of the week, Friday, end of the week, because John Deaton said she could come back with a ruling by the end of the week. So fingers crossed, we'll get a ruling by the end of the week, and let's just hope. Okay, that's my update that's my updates on the SEC versus Ripple lawsuit update as of last night. Okay guys, and I will catch you on the next one. Okay, keep safe. Okay.